Right, hello class. Welcome to week one. I'm going to cover chapter one today in our virtual lecture. So chapter one, we get into the legal environment of business and talk a little bit about that and what we might have coming up in the class. So some objectives for the first chapter is to explain common law and how it differs from civil law, the creation and development of common law, the development of statutory law, how common law and civil law systems differ, and look at some sources for administrative law, and also define stare decisis. So looking at the legal environment, why does it matter? An example they gave, a scenario, is if a car company prematurely releases a new electric car into the public without testing it first, how might this impact their business? And we can think about the outcomes of releasing that car too early. One could be that somebody gets injured, maybe they didn't take into account certain aspects of the car, or there could be something that they didn't see that was dangerous about the car. This has happened time and time again with the automotive industry. There was a car known as a Pinto, and it was known for exploding if it was rear-ended because of where the location of the gas tank was. And the Ford Motor Company had actually done calculations once they discovered that this was an issue to decide whether or not to recall the cars and have them fixed, or whether or not the number of lawsuits that they would receive, that it would be cheaper to just go ahead and pay for those lawsuits and let the cars explode and kill people. In the end, they decided to let the cars explode, and then finally, after so many did, the media caught hold of it, and they were still forced to recall the cars and fix the problem in that circumstance. So again, we have legal representation. We have laws on the books and statutes on the books in order to help protect us, and also to make sure that we don't get taken advantage of as individual citizens, and also for companies. So some different reasons for the legal environment, especially as we're thinking about business law, helps regulate business activities. And we look at different sources of American law in order to draw the legal standpoints for business. And where some of those come from would be English common law. And we'll also look at classifications under common law. And just a quick fact about where law comes from in the United States: most of our laws come from what's known as English common law. So this was the law that was created primarily in Great Britain way back when and over time. And then when the settlers came over, they brought the common law system over. But there are other types of law that have been integrated into the US legal system. Parts of the United States weren't settled by just English or people from Great Britain. For example, in the southern part of the country, especially in Florida, it was settled primarily by the French, and they brought French law over, and then it was later known as Creole or Cajun law, and they still today, you see some effects of that in the naming of their counties. They could be called wards, and other language they use for legal terms. So some areas that may affect us as far as decision making in business is concerned, and the legal system, we have the biggest one is contracts. And if you decide to go into law later on in life, you're going to find that 80%, 90% of the legal profession is primarily there to deal with contracts. We also have sales and e-commerce, negotiable instruments, creditors' rights, intellectual property. So intellectual property, again, would be like trademarks, copyrights, things like that. Professional liability, product liability, torts, agency, business organizations, environmental laws, and then legal experts that work in courts and with court procedures. So laws and regulations, they're here. to affect many of our activities. So we see the legal system in our hiring and firing of employees, in workplace safety with like OSHA, manufacturing and marketing products. Thinking about false advertising and how that can affect people. Business financing is an area where we see quite a bit of it today, just because of the bad actors that have taken advantage of the accounting and finance systems within major corporations to create great wealth for them and their friends within the organization. And we'll see many more examples as we go through the chapter in the book. And the author gave an example of YouTube versus Viacom. I pulled up this video so that we can get an idea of what they were talking about in that circumstance.
The importance of the case of the poopy Nintendo, but I think that we also need to recognize that there are bigger poops being put into more important Nintendos all across the world right now that we need to pay attention to. Obviously, BP is putting poop in the Gulf of Mexico's Nintendo. Israel and Palestine have so much poop in their Nintendos that nobody even knows where any of it came from. But much closer to home for all of us on YouTube, Viacom is attempting to put poop in YouTube's Nintendo. And this is a very big deal, so I invited YouTube and Viacom to go over to my house and sit down on my dining room table and talk it out. Unfortunately, both of them ignored my request, and so I had to do it all by myself. Hello, YouTube. Hello, Viacom. Your website is really nothing but illegally uploaded copyrighted content. We want two very reasonable things from you. One, we would like compensation for the videos that were viewed on your site that were illegally uploaded. And two, we want you to manually approve every single video that gets put on your site. Okay, let's take the first point first, because we might actually be able to do something about that. It might make sense for you to be compensated for your content. How much do you want for that? We would like $1 billion. How about instead we give you $2 per 1,000 views on all of the content that was uploaded illegally? That's more than anybody else gets. How about $1 billion? Okay, well, let's table that for now. But let's just be honest here. The vast majority of clips on YouTube are uploaded legitimately and legally by the owner of the clips, whether it's just some guy in his living room or whether it's a big media company like you. Whatever. Last time I was on YouTube, it was like all Daily Show and Family Guy clips. Was that 2007? Maybe. Yeah, well, since then, we have created the world's most advanced content identification system, which has all but eradicated illegally uploaded videos from the site. Be that as it may, YouTube would never have gotten as successful and gigantic as it is now if it weren't for all of the copyrighted clips. For example, let me read to you from an email from one of the founders of YouTube. Quote, if you remove the potential copyright infringements from site traffic and virality will drop to maybe 20% of what it is. Even if Stephen Chen meant to imply what that very out of context quote implies, Viacom has repeatedly put its own clips on YouTube trying to disguise the fact that it was uploaded by Viacom. How are we supposed to know what videos you want online and which ones you don't? That is not our concern. Your site is built on piracy and it is dirty. If we're so dirty, then why did you unsuccessfully try to buy YouTube? What? That has nothing to do with this. This is about our lawsuit. You profited from our content. Well, is it true that Viacom owns Spike.com routinely monetizes videos created by independent video creators with 30-second pre-rolls without the permission of the owners? This is not Spike.com's lawsuit. If those people want to sue us, they're welcome to. Okay, I get it now. So it's okay to steal from someone if they can't afford a lawyer. The independent content creators that you are stealing from, they're the backbone of YouTube. Oh, come on. Everyone knows that independent content is a mere sideshow when compared to the main attraction of illegal copyrighted content. Leaving aside that what you're saying is infuriating, it is also factually inaccurate. That's not possible. How could YouTube keep growing if it weren't profiting from pirated clips? Because our users, independent content creators, major media companies, all these people are uploading great content to YouTube that people want to watch. But they're not watching our content, and when they are, we can't control the way that they watch it. As far as we know, that is not against the law. But YouTube, you gotta understand, we can't handle this kind of change. We're an old media company. This is the kind of change that means we're gonna make less money. Okay, I see. Now we have gotten to the crux of the matter. Viacom, will you please take your poop out of our Nintendo? John, I will see you on Monday.
All right.
Good morning, John, and good morning to all the people who have never seen me before and who are asking.
So Yeah, kind of a funny clip about YouTube and Viacom and how they got themselves into a legal wrangling. So we look at sources of American law. We have constitutional law that's based on the US Constitution, statutory law. These are laws that are enacted by legislative bodies. Administrative law, these are rules, orders, and decisions of administrative agencies. Think of like the Federal Trade Commission or the Environmental Protection Agency. And then case law and common law doctrines. And these govern all other areas of law and are part of the common law tradition. So statutory law. In these circumstances, we're talking about local ordinances. This is covers municipalities and county matters not covered by federal or state law. And then the applicability of statutes. One example might be, and again, this is again a local ordinance, would be the idea of sanctuary cities. So cities that have illegal immigration as a misdemeanor or minor crime where you're not really going to arrest or charge people in those circumstances. We also have uniform laws formed by the National Conference of Commissioners on Uniform State Laws for Trade and Commerce, as well as the Uniform Commercial Code, which comes out of like it's a uniform law that all 50 states abide by. There could be tiny differences from state to state, but most states agree to abide by these general rules that are set up as what we now know is the Uniform Commercial Code, or UCC, and I have a quick clip on that as well.
In this video, we will discuss the Uniform Commercial Code. Together with the common law, the Uniform Commercial Code is one of the primary sources of contract law in the U.S. The Uniform Commercial Code is commonly known as the UCC, and it's actually one of many model laws or uniform laws in the United States. Among other things, Article 2 of the UCC applies to transactions for the sale of goods. So the UCC itself is a model law, so it's not exactly the law. As a model law, it's really a proposal that each state has to choose whether to adopt or not. But the UCC was enormously successful. Pretty much every state has adopted the UCC. Remember, different states can have different laws, but because each state has practically the same version of the UCC, we can expect contract law for the sale of goods to be the same from state to state. That's why you'll see something called the New York Uniform Commercial Code, and you'll see something called the California Uniform Commercial Code. It's just each state's version of the Uniform Commercial Code. By and large, the California Uniform Commercial Code, the New York Uniform Commercial Code, and other states' uniform commercial codes will be the same. So if we have a contract for the sale of goods and parties from different states, they can be confident that the same law is going to apply. So for purposes of most contract law classes and for bar review classes generally, you should consider the UCC as the source of law governing transactions for the sale of goods, and the common law is probably going to govern everything else: real estate contracts, service contracts, employment insurance, etc. If you'd like to discuss.
Okay. So that's a little bit more on the UCC code and how it's covered by different states. Moving on. Let's see here. We get into administrative law, and this is usually handled by different agencies, whether they be federal, state, or local agencies. And so we may also have levels of agencies. You may have a federal, let's say, Environmental Protection Agency, but we may also have a state level Environmental Protection Agency that takes into account specifics that have to do with the state of Colorado. We're a big tourism state, so we may have more rules surrounding things like drilling and mining, as opposed to a state that is less of a tourist state and more of, say, they get more of their money through the mining of minerals and oil and things like that. So sometimes you need to have a local agency that helps regulate different industries where you don't in other parts of the country. So some examples, again, the Food and Drug Administration, or what's known as the FDA, the Security and Exchange Commission. These oversee a lot of the financial workings of the United States, the stock market, how people file reports, things like that. And then the Federal Communications Commission. And we'll talk a little bit more about agency creation here in the next slide. So administrative agencies, they make new or amend old rules and also investigate and have prosecuting powers for organizations that don't abide by the rules that they've made. Adjudication, this is a trial-like hearing before an administrative law judge, and they're also known as an ALJ. Courts are given significant weight to ALJ decisions. So if you do something that affects one of these federal agencies' rules and you go to a criminal court, that criminal court will look back on the administrative judge for that particular agency or whoever passed down rules, and they'll generally use that as precedent, or they'll use that as a foundation by which to decide whether you had done something wrong or whether you had not done something. So we're going to take a little bit closer look at administrative law here.
In this video, we will discuss the Uniform Commercial Code. Together with the common law,
And that is the wrong video. Let me see if I can track it down here real quick. Got copied over here. Give me 1 second.
And manufacture of food and drugs. The Highway Safety Remember the fight over net neutrality? Activists and corporations battled over the structure of the internet. Both sides tried to convince the government that their way was right. But who were they trying to convince? Was it the president, Congress, the Supreme Court? None of the above. People were trying to convince the FCC, the Federal Communications Commission. The FCC is one of these things called federal agencies, and the laws around them are called administrative law. So there isn't a perfect definition for an agency that's consistent for all things called agencies, but roughly agencies are the parts of the government that aren't Congress, the courts, the president, or the military during wartime. Imagine that one of those things, either Congress or the president, decide to do something like building roads. Well, they're not going to pick up shovels in the concrete themselves. They're also not going to hire and oversee the workers themselves. Instead, they'll create an agency to carry out their goal. Agencies are most of the things in the government whose name is a jumble of letters, like the NSA, the FBI, the EPA, NASA, FTC, ATF, DOJ, DOE, etc. Agencies are formed by an act of Congress. Congress writes a kind of law called an organic statute that lays out the purpose and the structure of the agency. And then the agency is in charge of implementing that purpose as it's laid out in the statute. I like to think of federal agencies like giant robots. So Congress needs to deal with a specific subject matter, but that issue's kind of varied. They don't want to get into all the specifics themselves, but it needs to be dealt with. So they build a giant robot to deal with it. And while they're building it, they need to give it a structure that corresponds to its goals. An agency's structure might be designed to deal with investigating federal crimes, like the FBI, or maybe with promulgating standards for science and industry, like NIST. These different goals need different organizations to achieve them efficiently. A major part of the structure is the cockpit. Just like some giant robots have only one pilot and some have multiple, different agencies are headed up by different arrangements of officers. These positions are appointed by the president. Department of Homeland Security has one officer in charge of the whole agency who reports directly to the president. The FCC has multiple commissioners who all have slightly more independence. Officers in charge of certain very important agencies make up the president's cabinet. Also, while some agencies are totally independent, other agencies can actually be subsumed into one giant super agency. The organic statutes also give agencies a subject matter specific focus, like environmental protection or alcohol, tobacco, and firearms. Some agencies are purely internal and advisory, like the Office of Management and Budget, but most focus on some specific subject matter in society, like housing or trade. The language of these purpose statements aren't super specific because they need to deal with varied circumstances. Remember, the whole point is that Congress doesn't want to do the specifics themselves. So just like a pilot is responsible for implementing a more general mission plan, the agency's leaders are responsible for implementing a more general statute. This is why agencies are called semi-independent executive bodies. They get independence, but only within the scope of the organic statute. The agency's two biggest tools for implementing their statutes are rulemaking and adjudication. Agencies can make rules within their subject matter that have the force of law. They can also investigate, prosecute, and judge rule breakers. So we have these giant robots with legal power and independence. We've created a monster. Well, there are several mechanisms for controlling the agencies. First, Congress gets to shape the agency from the beginning. The agency is dependent on Congress for money and power and a purpose. Congress can call the agency head in front of a congressional committee and hammer them with questions. They can cut off funding for the agency if they want to, which will effectively disable it. Also, the president gets to put the pilot in the robot. They get to choose who's steering the agency. The president also gets to order the agencies around. These are called executive orders, and they're supposed to make sure that the agency is acting in accord with the will of the people. So besides these structural controls, the Administrative Procedure Act is the law's biggest source of control over the agencies. Congress passed this law, the Administrative Procedure Act, or the APA, in 1946. The APA controls the agency's tools of rulemaking and adjudication. Agency rulemaking is how the agencies take the general mandate of their organic statute and turn it into specific rules. For example, the Food and Drug Administration makes specific rules about the purity and manufacture of food and drugs. The Highway Safety Administration makes specific rules about the road. The APA says that most rules made by an agency must be open to notice and comment. This means that a notice of the proposed rule is printed up in the giant federal list of proposed rules, and the agency has to accept comments about the rule from all interested parties. The APA also says that the agency must respond to any comments that are substantial. Agencies also adjudicate claims of rule violations. For this purpose, the APA created the position of the Administrative Law Judge, or the ALJ. In general, ALJs have two primary duties in the administrative adjudication process. First, they oversee procedural things like depositions and witnesses, and they also determine the facts of the case. Then they make an initial judgment of the law and judge whether or not someone has broken the agency's rules. So ALJs act very much like a trial judge at a court, except they're constrained to a much smaller jurisdiction. The vast majority of ALJs work for Social Security, determining disability and dependency questions. Well, what happens if people think that an agency's rule is bad or illegal or even unconstitutional? The APA attempts to balance the government's need to control the agency with the agency's role as the executor of the law. Usually the courts defer to the interpreting its organic statute, when the robot is interpreting its mission. The courts are much more demanding when the agency is making claims about facts and reasoning. So, in conclusion, agencies are created by a congressional statute which gives the agency a structure and a purpose, and then the agency is given broad authority to interpret that purpose. The agency is piloted by one or more people who is chosen by the president, and then the whole agency is checked and constrained by the Administrative Procedure Act.
All right, so really good overview of administrative law and kind of how it works. So moving forward, we're going to watch a quick video on stare decisis so that we learn a little bit more about how common law has helped shape American law today.
Stare decisis. As we know, the common law is the root of American law. Stare decisis is Latin for let the decision stand, and it's a centuries-old legal concept handed down from the common law of England. Imagine stare decisis works like this. Whenever parties to a case appeared before a judge or jury, they would present certain facts. And based on the particular facts, the judge or jury would make a decision. These decisions or opinions were based on facts presented to the court. And then these decisions were written down, bound together in books, and read by other judges in nearby regions. Sometimes the published decisions from, say, Judge Anderson in one county in Oklahoma would help the decision-making of Judge Bartlett in another county in Oklahoma. Suppose, for example, that Judge Anderson wrote a decision called the Wandering Cow. That case involved a cow with a known tendency to wander out of its pasture and get lost, and sometimes do damage. The decision was written and published and read by Judge Bartlett in a neighboring county. Now, Judge Bartlett has a similar case in his own court. Farmer Joshua's cow wandered onto Farmer James's pasture, causing damage to James's crops. Judge Bartlett may use Judge Anderson's decision, the wandering cow, as a guide in his own court. But now suppose that the case of the wandering cow is appealed to the Supreme Court of Oklahoma. However the court decides, the decision of James versus Joshua will become binding precedent on all lower courts. So that, in a nutshell, is stare decisis. A higher court's decisions are binding on lower courts. Stare decisis helps courts be more efficient and stable because having precedent saves time and creates predictable legal outcomes. However, keep in mind that stare decisis is for the judicial branch. It can be overruled by a later decision of the United States Supreme Court, or perhaps by the legislative branch with a constitutional amendment, or even a new congressional law.
All right, so now we know a little bit more about stare decisis. Way back when in 1066 is when we started to develop certain rules that came about in England. And one of the things, and we'll probably learn this more later on, is that where law comes from tends to be where we sit as a society at some point in time. So to think about it, like we may decide at one point in time that we deem something to be unethical or creates harm to the public as a whole. And so at that point in time, we have a belief. It may be a belief based in ethics or values or our upbringing. And as that belief grows throughout society, when it gets to a certain point, we decide, okay, it's gotten to the point now where most of society believes the same way. Therefore, that belief has to be taken into account and maybe created into a law. And that's how most laws come about. If you think about for 1 second the idea of the legalization of marijuana back in the 1980s, 1970s, 60s, 70s, and 80s, it was deemed a harmful drug. I think it was a Schedule I drug, which is the hardest of all drugs as far as the Federal Drug Administration is concerned. And what we learned through science and over time is that there were some medical benefits, and then later on there were some recreational benefits to marijuana. And so as society has been changing, we've seen that states have been legalizing marijuana for use for both medical and recreational reasons. And we'll see over time probably that as that grows, as that public sentiment grows, it could become a federal law that is now legal throughout every state in the country based on federal statutes. So that's an example of how society can change over time concerning values and laws. So some schools of thought where law came from originally. There was the natural idea of law, and this was the idea that Aristotle had, that people had natural rights. Then there was a movement called legal positivism, and this was just where there was a belief that rights only exist because of laws. And then a historical school of law, past laws shape present laws. So again, the idea of precedent. One judge makes a decision and now other judges follow that decision. And then also the idea of legal realism. So they cannot be completely uniform because we are not all exactly alike. So in a lot of circumstances, even though there's precedent, a lot of times you need to be heard maybe in a court of law because your circumstances may be different than what the precedent that was set, and then that becomes precedent if the outcome is different than the earlier decision. Civil versus criminal law. So civil law basically means that you have wronged another person. And in those circumstances, let's just say that it could be you violated a contract, or you didn't pay for something, and you had a contract with somebody to do something like mow their lawn or something like that, and you didn't mow their lawn. They can take you to court as a public person, and that would be a civil law case. And then you have criminal law, in which case it's gonna be some form of a tort that's committed against society as a whole. So this could be financial fraud, it could be kidnapping, it could be any stage of harming somebody, but that's generally going to be a criminal law, and that's considered to be a law against society in which the police, the county, the state, or the federal government are the prosecutors in those circumstances. So in civil law, another person, a fellow peer, is a prosecutor, and in criminal law, it would actually be some form of government that is prosecuting the case. And so the differences between common law and the civil law system, the English common law system and the Roman civil law system, they dominate the globe today. You also have national law and international law. International law are things like treaties between countries. Sometimes we have business treaties between countries, so that if we are accepting the import or export of goods, we know that we have some form of representation when it comes to if we're misled by what these goods are, or if they cause some harm to our citizens here in the United States. There is some form of repercussion for a company that is outside of the United States jurisdiction through some form of international law. It's not very strong. It's a pretty weak system, but there is some retribution if need be in those circumstances. Okay, so how do you find out about what laws protect you, what's on the books? Best thing to do is use a law library, and there is an online law library called Westlaw. It has most of the information that you would need, but there are also generally brick and mortar libraries that have actual legal books in them. Some of those are donated from law schools. You can go in and they're generally pretty extensive, so you want to be able to figure out. You should have an expert at the library be able to point you in the right direction, so that you can narrow down what you're looking for. You may want to start with things like the U.S. Constitution and state constitutions, and then look at any regulations that have been developed through administrative agencies, federal and state statutes, and then you're going to get down to the more detailed court cases in those circumstances. So in summary, this chapter, we kind of talked about common law and civil law, also looked at the creation and development of common law, explained the creation and development of statutory law, how common law and civil law systems differ, looked at sources of administrative law, and we looked at stare decisis as far as a term that basically oversees the way that our judges and our law system uses precedent or past laws to look at current law, especially in the court system and when deciding court cases. So that is it for this particular chapter. Have a great week. I look forward to seeing you guys again, and look for the if you're in class, look for the next in-class lecture. If you are taking the class virtually, I should have future virtual lectures coming soon. Thank you.